The Sarasota County Bar Association is a proud partner in bringing you law in Sarasota. With voluntary membership of over 1,000 lawyers and judges, the Sarasota County Bar Association serves its members and your community by advancing legal professionalism, promoting practice development, and fostering fellowship. Visit www.sarasotabar.com for more information and to use the online directory to find an attorney.
This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible. Welcome to Law in Sarasota. This is a program sponsored by the Sarasota County Bar Association with the goal of informing the public of the legal issues that impact daily lives. There's a quiet revolution underway in Florida courts. Programs have been developed that aspire to address the root causes of criminality. In other words, in addition to punishing offenders, judges are learning to look into the reasons why so many citizens return to the criminal justice system and to seek ways to reduce recidivism. In Sarasota County, a judge took it upon himself to have the initiative to establish one of the most innovative programs in the state, one that treats a demographic that poses a daily threat to the health and property of innocent people in our community. The program is called the Sarasota Dui Court, and it targets repeat offenders, people who have more than one DUI. So let me introduce the organizing force behind Dui Court and the judicial officer who oversees its operation. Welcome, David Denkin.
Thank you, Lee.
So first, let's tell us a little bit about your background and education and gradually how you got into the Dui Court program.
All right, starting forward and going backwards, I've been a judge now for 19 years. When I became a judge, it was because I ran for the position. It was an elected position for me. Some judges are appointed. My position was available by election. Before that, I was a criminal defense lawyer for 18 years, and before that, I was a prosecutor for 2.5 years.
And as part of your criminal practice, I assume you represented people charged with driving under the influence.
That was probably one of my most common charges.
So, in addition to your role as a judge, you also have certain leadership positions with the Conference of County Judges. What was that about?
I'm past president of the Florida Conference of County Court Judges. There are 322 county judges in the state of Florida, and I was privileged enough to be elected president 3 years ago.
What did you see that inspired you to conceive and to implement the Dui Court program?
Well, what I saw people coming back to court for the same offense. When I would have people come before me for DUI charges, looking through the record, this wasn't their first dance, it wasn't their second trip to the rodeo, it wasn't their third or fourth. And so what I figured was, there's got to be something to do about it. And then I did some research and found out that there are DUI courts throughout the United States. And then I looked into whether or not Sarasota would be appropriate for having a DUI court.
When we speak in terms of a DUI court, we're talking about a problem-solving court, and we have several of those. We have a drug court, we have a veterans court, we have a community health thing, but you chose the DUI aspect. What problems do DUIs present to the public as a whole?
Well, they're devastating in what they can cause families. There are felony DUIs and there's misdemeanor DUIs. A felony DUI is either a DUI that's either a third or fourth or more, or it's a DUI that involves death or serious bodily injury. Getting behind the wheel of a vehicle under the influence of either drugs or alcohol makes that vehicle an extremely dangerous instrumentality. So
where did you go to find out how these courts work?
Well, I did some research, and there are 4 Academy DUI courts. By Academy DUI courts, there are 4 DUI courts in the United States that teach judges to run their own DUI court in their own community, in their own district, in their own county. So I did some research to find out where they were. The closest one for me was in Athens, Georgia. The second aspect was to determine whether or not they work. The third aspect was to determine whether or not this county was amenable to establishing a DUI court.
So you had to build it from the ground up. So you have funding issues, you have staffing issues. How is that addressed?
Well, the first issue was convincing the state attorney's office and the county commission to get that done. And I'm not good at about convincing people to do anything, quite frankly. So to be honest, three people that helped the most was Walt Smith, who was our court administrator at the time, Erica Quartermain, who was the court counselor. She's now a county judge, but she was court counsel at the time, and she helped me do the research and put the package together. And you, if you recall back in 2007, you took me around to every county commissioner, introduced me to them, and gave me the opportunity to explain to them what the program did.
So you started this in what year?
2008. June of 2008 was our first court.
So let's talk a little bit about what people who are faced with DUI charges, what are the typical penalties, first time and then second or third time? What are they looking at in the way of punishment?
The DUI sanctions increase with their priors. They increase with the amount of, if it's a breath test, if it's a high blow. They increase based upon whether or not there's bodily injury or property damage. But they're one of the few crimes in the state of Florida that have so many mandatory minimum consequences. For example, for a first-time DUI, has to be on probation. They have to go and complete DUI school. They have to go and complete community service hours. They have to have their license suspended for a minimum of 6 months, up to a year. They have to have their vehicle impounded. It's like placing their vehicle in jail for 10 days. And those were all, and the fine and court costs, all mandatory. That was for a first-time DUI. It wasn't really aimed at treatment. It was just aimed at punishment. Second-time DUI, within 5 years, requires a mandatory 10 days in jail. Everything else remains the same. Third-time DUI, within 10, 30 days in the county jail. It's also going to be treated as a felony. Fourth-time DUI, no mandatories, other than probation, DUI school, and the fine.
And I guess a lifetime suspension of driver's license?
Right.
Okay, so tell me how the DUI court attempts to address that problem. How do you set the court up? What are the phases that you have to go through? Let's talk first about how you qualify to get into the DUI court. Who has to say yes? Who has to approve the backgrounds and say, now you can participate with Judge Denkin?
There is a process to getting into the DUI court program. The first process is they've got to want to be in. The second process is they have to be evaluated by my team staff. And they're evaluated for two reasons. They are medically evaluated, and then they're evaluated based upon their prior record. Medically, I can't have people coming into the program that are already taking prescribed narcotics, controlled substances, and they're not willing to titrate off to a non-narcotic substance. Because I, as the judge and my staff, can't determine whether or not they're using because they have an issue or to deal with their medical problem. That's number one. The second deals with the prior criminal record. If they have a violent criminal record, then I can't place them with my other participants, and with my staff, it's not safe to them. So I'll make that call on a case-by-case basis.
How about drug dealers?
I've accepted people that have sold drugs before.
All right. So I guess you get a lot of referrals from the Bar Association, defense attorneys see advantage in this. What do they see in this that they help sell them to with their clients?
The biggest thing the clients go in with is, I'm going to get less jail time. I know that's what the attorneys tell them because that's what I used to tell my clients when it was drug court and I was a criminal defense lawyer. And that's fine as one of the reasons. Can't be the sole reason, but that's okay if it's one of the reasons. They need to admit that they have an addiction or an issue with drugs or alcohol, and they need to be willing to work, because DUI court is tough, and I tell them that all the time.
It's not a walk in the park, I guess. And we'll get into the details of what is required of them. So there's a benefit to the accused to participate and be successful in this. Are there financial requirements?
Yeah. One of the studies, there's a lot of studies that have been done about what works and what doesn't work with addicts. And what does work is they have to buy into the program. For example, when I was a lawyer, if somebody came to see me for free and I didn't charge them anything for the legal advice I gave them, it always turned out that they didn't take it as seriously if they paid me a consultation fee. Same thing with going into drug court or DUI court. They pay a fee, a monthly fee. And from that fee, they pay for their drops, their urine drops, and they pay for their counseling and their treatment through the program. And they have a invested buy-in, a financial buy-in to their treatment.
Well, that's in addition to the normal fines and requirements that the law imposes for DUI?
Yes, it does. But if they're financially strapped, they can still come into the program. I will give them a scholarship for entering the program. They'll pay a lesser amount, but they have to pay something. And their fine and court costs, which are extremely high for multiple DUIs, they can run as high as $5,000.
Would you allow them to perform community service if they're unable to pay?
Exactly. They will provide me with a financial affidavit. And under the statute, if they qualify, I will allow them to do community service work to work off a portion of their fine and court costs.
Just speaking in generalities now, how long is a program from the time you accept them in until the time, I guess you call it a graduation?
It's a minimum of a year.
Okay. And what are the steps they have to go through in that year? How long do they stay in each phase?
There's 4 phases, and it depends a lot on them. There's a minimum period of time for each phase, but it depends on their progress. Phase 1, we have much more supervision. Phase 2 is a little bit less. Phase 3 is a little bit less. And Phase 4, we're getting them ready to go out on their own and not have us looking over their shoulders.
So are the tasks that are part of each phase increased? What are examples, some of the things they have to do in Phase 1?
Okay. First of all, in Phase 1, they need to complete their jail sentence. Whatever jail sentence that was imposed, that needs to be out of the way in Phase 1. I don't want it hanging over their heads. I want to get them straight into treatment. So whatever jail sentence I impose, it has to be done in Phase 1. They have to look into signing up for DUI school. They need to start looking towards the initial requirements of the program. They have a lot they have to do. They have at least a minimum of 3 drops a week, and they're random.
Explain what that means.
That means they have 3 urine drops a week that's going to happen. It may be more, but it's going to be at least 3 drops a week, and they have to call in every day. There's a phone number they call in, and if their group is announced, they have to drop that day. If they don't show up, it's counted as a positive.
And where is the testing done?
We do it in Venice for those people that live in Northport, Englewood, and Venice, and we do it in Sarasota.
So is there a lab?
There's a lab.
Okay, and they actually can get the result. How long does it take to get results?
I get the results in 24 hours.
Okay, so that basically would be Phase 1, and that's what, about 45 days?
60 days.
60 days.
And usually, and by the way, that's not all they're doing. They're going to 3 group meetings a week. They're going to individual counseling sessions. They're attending at least 3 AA meetings a week, or they're equal. In other words, I don't make them attend AA if they have an objection to the religious background of AA or foundation of AA. We have alternative AA meetings which are not religious foundation programs. And then they have to start doing what I had to sentence them to also, such as the DUI school, the victim impact panel, payment of fine. They have to either be working, going to school, or doing community service work. They are extremely busy.
Okay, and so they progress hopefully to a second phase.
Right, and this program is designed for reinforcement, both positive and therapeutic, immediately. We have, oh, I forgot to mention, they have to come to court. They have to see me once a week. That's tough enough for most people.
Yeah, okay. So how do you deal with the fact of relapse?
Relapse, that's why when other judges send their cases to me, I try to make sure that they transfer the authority of that case to me so that if they violate relapse, then I get to decide whether or not they get to stay in the program or not, as opposed to it usually being on regular probation. It would have been an automatic failure. But in a problem-solving court such as drug court or DUI court, they have the chance to stay in the program but just deal with the issue. And whereas in regular probation, it would take 2-3 months to go to court to deal with that issue, in problem-solving courts such as DUI court, within 7 days, we're dealing with whatever relapse issue occurred.
Well, you spoke about a staff. Who supports you with this? Of course, you've got your work to do. Most people don't realize that judges really only have one employee, right? And that's a judicial assistant. But the county has provided you support staff. Who are they and what do they do?
Yeah, thank goodness for the county. I have an executive director that runs the program who meets with me more than once a week. I have a case manager who keeps track of all the pending participants we have. I have 2 counselors who address the needs of the participants on a weekly basis, and they help run the groups. I have lab techs that run the urine test every time they're done. I have the assistants of the state attorney's office and the public defender's office. They're all there every week.
Wow. And there's a mental health component.
Yes, there is.
Is that counseling? I mean, do you have therapists that meet with these people?
I have a doctor. I have a nurse. And when it's warranted, because a lot of people that come into court with a DUI, it's not just the DUI that was the problem. They may have a dual diagnosis. In other words, they have an addiction and a mental health issue. So we try to address everything that needs to be addressed.
All right. So do you, give us an example of how you would conduct an actual in-court process, assuming you had people out here in the audience that were part of your court. How do you open it up? How do you talk to them? What sort of encouragement do you do or information do you impart?
Well, are you talking about the DUI court or about the plea when they first come in?
Let's talk about the plea first.
Okay. When they come in for a plea, it's a straight-up plea. And by that I mean it's an open plea. And by that I mean, for your audiences, there is no guarantee as to what their sentence is going to be. There is no guarantee that they will get into DUI court. They're asking for DUI court, but there's no guarantee. They plead straight up. They also plead guilty. In Florida, you can either plead guilty or no contest. No contest means I'm not admitting to the charge, but I'm not contesting the charge. Go ahead and sentence me. I have them plead guilty because I want them to tell me, yes, I was driving under the influence. Because if they can't admit to that, we can't go any further.
All right. What if they fall off of the drug court? Does that come back to haunt them, their guilty plea?
No. If I decide that they're not acceptable for DUI court, I will do one of 2 things. I will allow the attorney to ask permission to withdraw his plea and go in front of the original judge that was assigned to the case. Or if it's my case originally, I will just continue and sentence them to something other than DUI court because it's an open plea. And we go through that conversation very clearly.
So there's no confusion about what their risk they're taking and what their obligation is. You also spoke in terms of very clearly laying out what their responsibilities are, how difficult it's going to be. Do you find them accepting of that for the most part?
They read and sign a 4-page document, which is, by the way, on the 12th Judicial Circuit website. It's the application DUI court agreement. It's 4 pages, and it lists all the things that are going to be required of them. no use of alcohol or drugs, no use of spice or K or kratom, whatever they're calling it this week. They have to show up for groups. If they have 2 or more dilutes, that means if their urine drops come back diluted twice, anything after that's considered a positive. If they don't show up for a drop, it's considered a positive. We go over that contract that they read and signed, because I have the contract in front of me during the plea colloquy. They've already read it and they've already signed it along with their lawyer.
Well, you've told us about the plea. How about when you have one of those sessions where they're back, they've been in the program for a while, what sort of things do you tell them or try to encourage them?
Well, we start court at 4 o'clock on Thursday. 3 o'clock on Thursday, we have assessments. I have all my staff meet with me, and we go over everybody that's in the program. We talk about how they're doing, anything they need, any problems at home, any relapses, any issues with violations of the agreement, anything that they're doing well. And then at 4 o'clock, we start court. And the way we start court is the first thing I do is positive things. Graduations. If we have any graduates that week, we do the graduations. After the graduations, I announce those people that are phasing up. They start in phase 1, they go to phase 2, phase 3, phase 4, and then they graduate. They get certificates for phasing up to phase 2, to phase 3, and phase 4. I announce those. Then I announce a group we call the Z team. We start Z team because of Zoom. We're now on Zoom. That is people that have been in the program for an extended period of time and are doing things extremely well. We acknowledge all those people and we give them a little ovation.
You've been doing this a while. Do you see things that are typical triggers to people that cause relapse?
Oh, yeah. Hanging out with their old friends, fights with spouses, significant others, bad day at work, good day at work. Just about anything has been I've seen as triggers for the people in the program over the past 13 years.
I take it, since you're so involved with this, that there have been opportunities for you to teach to other people or other courts about how to get into this process?
I've taught at the National Judicial College, and I've taught in Florida. I run a DUI course. It's called a Traffic Adjudication Lab course, and I'm the dean of that. And I've been teaching DUI court in that program. It's a week-long course, and one afternoon I spend teaching DUI court, and I've been doing that for 9 years, I guess.
Okay. I guess also you've taught courses on DUI prosecutions and legal issues that judges have. I remember we went through a whole phase on breathalyzers.
Right.
Where is that now?
The last round of Intoxilizer, that's the machine, Intoxilizer 8000 motions, I heard the most recent one was, I guess, last month. So I haven't heard of any new ones since then.
Well, for people not familiar with the controversy, I think since the breathalyzer was invented, there have been challenges of scientific types coming in and saying it's inaccurate for this reason or that reason. And we went through a whole phase a couple of years ago where the whole thing was very skeptical and the appellate courts were all over the place. We had a backlog of DUIs.
Yes, we did.
I guess you got involved with that too. So on the DUI court, do you think that you have enough people participating? I mean, what is your population? How many do you have?
I have over 50 right now. My group has been as high as 90. I have over 525 graduates in the program.
So you handled every one of those?
I'm the only one that does DUI court.
And I understand you have a tree. Tell me about the tree.
Oh, the tree. Long time ago, I decided that the graduates needed something solid to see once they graduated from the program. So I decided to get a Ringling art student to paint a tree. And the trunk of the tree shows the 4 phases. Phase 1 on the bottom, all the way up to phase 4. And all the branches and all the leaves are painted on it. Each leaf has an initial of a graduate. So when they graduate, they get to put their initials on the leaf. I now have 525 leaves and initials, so I've had to double up on some of the leaves. It looks like a bush now.
So what's your recidivism rate?
Well, let me back up and say that the national average for recidivism for DUI is about 25%. Florida's average is about 25% as well. My DUI court is at 5 or 6% right now.
95% success. That's remarkable. No doubt saved a number of lives and people from being injured. You brought with you a demonstration. Tell me what this is.
We have a lot of...
I'll hold it up so the
Okay.
camera can see.
We have a lot of tools in DUI court. I like to talk, and I like them to see things visually and get involved. So when I run DUI court, one of the first things we established was what is required of me. So every week they see that. I would tell them this too. I require only 3 things. If you want to stay in this program and you want to come out better than when you came in, I only require 3 things. Number 1, I need you to show up. If you can't show up, I can't help you, my staff can't help you, and you're wasting your time and my time. The second requirement is try. I just want you to try. If you give up trying, then we're wasting each other's time. The third thing is the hardest, and that is to be honest. And when I say be honest, it's not only being honest with my staff and myself, it's being honest with yourself. Because once you're honest with yourself as to why you're here, then we can start working on making a better you.
Well, thank you, and thank you for bringing this. As you have seen, Judge Denkin works with a tough demographic. Anyone who has personally experienced alcoholism or who is close to an alcoholic knows how hard it is to maintain sobriety. It's especially important that active alcoholics not drink and drive. The harm they cause far exceeds their number. The Sarasota DUI Court is one effort local judges are making to correct behavior that can lead to arrest and jail. If you would like more information about Judge Denkin's program, additional information is available on the 12th Judicial Circuit website. Thanks for watching. This is Lee Hayworth signing off for Law in Sarasota.
For more than 40 years, the Community Foundation of Sarasota County has partnered with estate planning attorneys and their clients to unlock possibilities for everyone who calls our region home. Our motto, Be the One, reflects our deeply held belief that anyone can be a philanthropist and give back to our community regardless of means. Visit www.cfsarasota.org or call 941-955-3000 for more information.